My name is Jean Hemphill, and I serve as the legal counsel of the Board of Pensions of the Presbyterian Church, U.S.A. I'm also a partner at Ballard Spahr, a law firm, in its Philadelphia office. It is my pleasure to collaborate with my colleagues Michael Kirk and Angela Curry, the General Counsel of the Presbyterian Foundation, in presenting these educational webinars on the Families First Coronavirus Response Act, the Families First Act, and the Coronavirus Aid, Relief, and Economic Security Act, commonly known as the CARES Act. These are the two laws that a bipartisan Congress miraculously passed in March 2020 to provide relief to employers, employees, their families, and other individuals arising out of the coronavirus emergency. My segment of this PCUSA agency webinar series will cover the employee benefits provisions of the Families First and CARES Act, including important relief related to retirement and health benefits and the administration of those benefits plans. As you can see from this summary list of changes I plan to cover, there are a number of subjects, including new rights of retirement plan participants to withdraw or borrow money from their accounts to cover financial expenditures that were unexpected, or to defer or delay required minimum distributions from retirement accounts because of the decline in the stock market. On the health plan side, there are changes to coverage by health plans for the coronavirus test and treatment related to it, and coverage for telemedicine in this time of stay-at-home orders and other government isolation requirements. Let's first address the retirement plan issues. The CARES Act authorized a new defined contribution plan distribution option for participants. It is available to 403B, 401K, 457B, and IRA plans. If a qualified individual, and by that I mean a plan participant, a spouse, or dependent of a plan participant, has been diagnosed with the COVID virus, has experienced financial consequences as a result of being quarantined, furloughed, or laid off for a reduction in hours, or has been unable to work due to lack of childcare or school for their children, or meets other Treasury Department factors that may be announced, that individual is eligible to take a coronavirus-related distribution, or what we will refer to as a CRD. A CRD can be a distribution made from the plan while you're still actively employed, similar to a hardship distribution, but there are different requirements. Or it can be an early distribution for a terminated vested participant. In other words, someone who has already retired or stopped employment, but is not yet in pay status under their plan because they haven't met the normal retirement age, or an age when they want to start taking out their retirement benefits. These distributions are not typically available from a defined benefit plan. The Board of Pensions has not adopted CRD distributions for their pension plan because the pension plan does not have any lump sum distribution options. The terms of the CRD are as follows. You can take up to $100,000 from your account, and it will not be subject to an early distribution penalty of 10% if you have taken it prior to age 59 and a half. Distributions taken after 59 and a half are not subject to that penalty normally, and CRDs are not as well. This distribution option is only available for calendar year 2020. A very unique feature of the CRD is that you can repay your retirement account for the distribution over a 3-year period. And you can make that repayment to either the plan you took the money out of or any other eligible retirement plan or IRA in which you participate. The taxation of the distribution, and all distributions from retirement income from retirement plans are typically taxed at the time you take the distribution. But in this case, you can include the income proportionally over a 3-year period, thus, extending your tax obligations over a longer period. In addition, it's not subject to the normal 20% mandatory withholding rule. Plans may implement these CRD provisions immediately if they would like, and then thereafter they have a period of time to formally adopt a plan amendment. I'd like to turn now to the defined contribution loan provisions that I mentioned. There is a temporary increase in the amount that you can borrow from your defined contribution account. Namely, for the next 180 days, beginning March 25, 2020, you can take a loan from your account, if your plan has loan provisions, for up to $100,000. The limit prior to the CARES Act was $50,000 for loan amounts. In addition, you may borrow up to 100% of your account balance. Now, not every defined contribution plan provides for a loan option, and it is completely discretionary on the part of the plan sponsor as to whether or not they want to adopt a loan provision or adopt these increased loan amounts for this temporary period for CRD-related expenses. If you are in a plan that has a loan provision, there is an ability to defer a loan repayment to the plan. The CARES Act gives a 1-year extension to repay loans from a plan if the due date for that loan occurs between March 25 and December 31st of 2020. If you do defer the payments, the subsequent payments will be re-amortized over the new 1-year payment period. When you go to access money from your retirement accounts, whether you do it as a CRD or as a loan provision, you will need to consider carefully which is the better way to take the money out of your account and what options are available to you if your fortunes should turn after the end of the COVID crisis and you are able to or want to restore money into the account that you've taken out during this temporary, hopefully, emergency crisis period. As I stated earlier, the law has certain provisions in it relating to the required minimum distributions that participants of defined contributions plans are required to take when they retire and reach age 72. The minimum retirement age was 70 and a half before the Secure Act, so many participants before 2020 retired at age 70 and a half. The new age for RMDs is 72. In response to the stock market declines, the CARES Act allows a participant to suspend their required minimum distribution withdrawals in calendar year 2020 so that they don't have to take their money out of the market while it is at such a low level. However, Many seniors depend on these withdrawals for their retirement income, and whether or not to defer RMDs is completely voluntary. There is no requirement that a senior must stop the required minimum distributions. As noted before, a plan sponsor has time to make the amendments, to adopt the amendments for their plans to cover these new provisions. And we expect the IRS and Treasury to come out with sample plan language in due time that an employer can consider in adopting plan amendments. The Board of Pensions Benefits Plan has already adopted plan language for these amendments, and these benefits are fully available to participants and members in the benefits plan and the retirement savings plan. If you are an ERISA plan and church employers that sponsor church plans are not subject to ERISA, but if you have an ERISA plan for some reason, the ERISA reporting filing dates have also been extended for up to 1 year. But as I said, if you are a church plan, you're not subject to ERISA, and these filing requirements do not apply to you. There are a few other retirement plan issues that I'd like to quickly cover with a few words of lawyerly caution. The obligation of employer to amend their plan and offer these different new requirements, and the rights of members or participants to access them may depend on whether the employee is still employed, has been terminated or laid off, or furloughed. So let me give you a few examples. A furlough is not a severance from service. It is a temporary cessation of certain pay, perhaps certain benefits, but in and of itself, it is not a termination from employment, so rights that relate to an employee because they've been terminated wouldn't apply. Another factor, and I don't think this applies to many of the plans that sponsors that I'm speaking to today, if too many employees are terminated from a pension plan, a defined benefit plan, it may constitute a permanent termination of the plan and result in certain potential withdrawal liabilities if you're in a multi-employer pension plan. So again, when making employment decisions, the employer always needs to check the plan document and its terms. Let's turn now to the next slide and start our discussion of healthcare benefits. Both laws and the guidance that has followed facilitate and in some cases require health plans to cover benefits and pay reimbursement to providers providing those benefits that relate to COVID healthcare events. First, the Families First Act eliminated any copayment requirements or cost sharing for COVID testing or healthcare provider visits related to COVID diagnosis or treatment. Secondly, this same provision will apply to any kind of testing that is permitted to be given, even if those tests have not been approved by the FDA and under normal circumstances would probably be considered experimental testing under your pre-COVID healthcare plan terms. The CARES Act also provided certain provisions relating to the reimbursement that plans will make for these test procedures. When vaccines become available, CARES Act requires health plans and insurance companies to cover those vaccines as COVID preventative services or immunizations, and as a result of that, those vaccines will be available as preventive healthcare services and therefore not subject to the copays and deductibles that are typically due for healthcare treatment under your healthcare plan. When those immunizations become approved by the government, then these COVID requirements for health plans will take effect 15 business days after that time. For those employers offering high deductible health plans and health savings accounts with them, or employees who have enrolled in those types of medical plans, the CARE Act also includes a temporary exception for calendar year 2020 through 21 for the payment of telehealth services without requiring the participant to meet the high deductible of a high deductible savings plan. In other words, they will be treated as if they are preventative health services and therefore not subject to a copay or deductible under your plan. The IRS had earlier provided guidance that the telehealth exception only applied to testing and treatment services for COVID. The CARES Act expanded that and now allows you to have telehealth services for all treatment without copay or deductibles. Unfortunately, many employees are being laid off or suffering reduction in their hours due to the closure of their employers for non-essential businesses in many states. As a result, questions have arisen as to whether or not those circumstances constitute qualifying events so that mid-year elections changes can be made to amounts that have been set aside under flexible spending account elections. As shown in this slide, these mid-year changes are now permitted. Generally, as a result of the COVID crisis, a participant in a health FSA may make a change to their elections to put in money to their health FSA if they have a reduction of hours that causes their loss in medical coverage, if they have a change in their employment status, if they are out on FML leave, or their employer has substantially changed their benefits program or cost. Under the dependent care FSA, a participant can now make changes for all of those same reasons, but also if there is a change in the availability of their health care, their child care coverage, or the cost of that coverage. So if you are now homeschooling or doing some arrangement other than your paid child care and therefore will not need as much money in your dependent care FSA, you can make a mid-year change. Likewise, changes have been made to the right to make mid-year election changes for health savings accounts and health reimbursement accounts. For a health savings account, the employees can update their elections at any time and for any reason. They can also make a contribution directly into their health savings account if they can no longer do it through a payroll deduction because of a termination. The IRS has also extended the time within which individuals can file their 1040 tax returns to July 15, and correspondingly, you may also, the CARES Act allows HSA account holders to make contributions to their 2019 health savings account at any time up until the July 15 deadline. Health reimbursement accounts, which are the accounts that employers fund, not employees, have certain liberalizations that would allow them to allow their terminated employees to submit claims for expenses up to the termination date of the HRA or any claim submission deadline that the employer establishes for the program. Further, if the employee elects COBRA continuation or medical continuation, if it's under a church plan, the HRA can continue to cover those expenses. The CARES Act also made changes to certain medical expenses that you may have that were not previously covered under FSAs, HSAs, or HRAs. In a provision that was an amendment to the Affordable Care Act, they removed over-the-counter medical expenses as eligible expenses for reimbursement from these types of accounts unless you had a prescription from your doctor for that over-the-counter drug or supply. The CARES Act realizes that we cannot be bombarding providers for prescriptions for these matters, so they have now amended that provision, and so you may now buy non-prescribed over-the-counter medications and medical supplies, and they will be qualified medical expenses that can be covered by your HSA, HRA, or Health FSA. We would recommend that you go to your administrator of any such account and get the list that they have now updated that shows exactly what medications and what supplies are now reimbursable under this expansion of the qualified medical expenses. This change was retroactive to January 1st, 2020, and it does not include an expiration date at this time. I want to just mention two other provisions relating to, really in response to questions we've received from employers and employees who may have lost their employer-based coverage as a result of an employment decision relating to COVID economic circumstances. Can you go and enroll in the Affordable Care Marketplace Exchange plans at this time, or do you have to wait for the next open enrollment period? And the answer is, if you've had a qualifying life event, in other words, if you have lost your employer-based health insurance, you are eligible for a special enrollment period and can go and enroll in an Affordable Care Act plan. But if you simply have lost some of your wages but not your coverage, that would not be an event which would allow you to switch to Affordable Care Act coverage, which because of your change in income might be less expensive to you. There is a possibility that there may be a special enrollment period, but to date the administration has not chosen to do that. Some states who sponsor their own exchange marketplaces have created limited special enrollment periods for these circumstances, so if this is something of particular interest to you or your employees, you ought to check with your state marketplace exchange plan. As I've said, church plans are generally not subject to ERISA or COBRA, but they offer comparable benefits coverage and medical continuation plans. But the purpose of this slide is to inform those who may have an ERISA medical plan for some reason that they need to be aware that some of their employment decisions may trigger COBRA obligations. If you terminate the employee or furlough an employee with the loss of health care coverage, it is a qualifying event that would trigger COBRA coverage obligations. They include the obligation to issue notices to the health plan members that they have the right to elect COBRA continuance. And I would also note that those notices advise them that they are also eligible for state marketplace exchange plans under the Affordable Care Act if they have a loss of coverage due to such employment action. On this slide, I just wanted to capture some of the Medicare provisions that were enacted by the CARES Act or adopted by the Centers for Medicare and Medicaid, known as CMS, in response to the COVID-19 emergency. These provisions generally mirror the same provisions that we've reviewed for your employer group health plans. For example, Medicare will now cover telehealth services, and including virtual check-ins. They will allow you to go through online portals. And the important part of this is it allows the physicians to provide the services through these telehealth media and to be paid for those visits. And it allows the Medicare beneficiaries to access to their physicians without having to go out and expose themselves to COVID-19 exposure. So in addition to the telehealth expansion of services, the COVID lab tests are also covered without any cost sharing or out-of-pocket cost under Part B. COVID preventative tests, screenings, and vaccinations will ultimately be covered by Medicare. Any necessary hospitalization, including a hospital stay under a quarantine, will be covered by Medicare, and certain pre-authorizations or prior authorizations for Part D drugs that are used to treat coronavirus are waived under the Medicare program. And finally, the CMS is now allowing the early prescription of refills for certain prescriptions so that individuals do not have any disruption in their medication regimes caused by their inability or concern about going out to their retail pharmacy as often as they might need to do under their prescription. You should check with your Part D plan to determine the specifics of those arrangements. On this final slide, I'd just like to advise you that the Board of Pensions has adopted all of the available programs under the CARES Act and Families First for the benefits plan so that its members and their families can take advantage of this relief. They have amended the retirement savings plan to allow for the CRDs or the COVID loan provisions. They have updated their minimum distribution age to 72 and will allow for the 1-year deferral of minimum required distributions if a participant or retiree elects to defer their MDRs. They have they have waived the copayments and deductibles for testing and COVID-related treatment. They've adopted the waivers of copayments for telehealth services. They have worked with further the administrator of the health savings account, health reimbursement accounts, and FSA plans, and they have adopted the features that we went over that pertain to those plans. And more information, good information, is available on the Further website to answer any questions you may have about those programs. The Board of Pensions also has a COVID-19 website. It has a lot of very good information on it, including a summary of all of the CARES Act provisions that an employer may be interested in, not only relating to benefits, but also some of the payroll protection features and the refundable tax credits for employee retention that are available through that program and covered in my colleague Mike Kirk and Angela Curry's presentations. And that summary was prepared by a number of lawyers representing the Church Alliance, which is a coalition of over 40 denominational church plan organizations. And they have prepared that summary, and it is available on the board's website. In addition to adopting all of the changes that the CARES Act and Families First Act made possible, the Board of Pensions also has adopted dues relief. They have a program for small churches, meaning churches with fewer than 300 members and an installed pastor, to get dues relief for that installed pastor's participation coverage for up to 3 months. They also have a program where they will defer the payment of 2 months of dues for other churches and other affiliated employers, and an installment plan for the repayment of those deferrals throughout the calendar year of 2020. Frank Spencer has a good video on the Board of Pensions website, which is pensions.org, where you can hear more about the dues relief that the Board of Pensions is offering. I hope that this information has been helpful to you and that you can access any of these benefits that you may need. God bless, and thank you.